question is, how are you doing today?
I'm doing fine. A little sleep deprived, but otherwise better.
Same here. All right. Well, congratulations on making it to quarters. And my first question is, so we talked about having tangible harm within our case. Now, specifically for having an efficient system, would you agree that if military commissions remain a viable option and remain a valuable option, that they should be kept?
Yes.
Right. So it depends on whether or not they're actually valuable, correct?
Yes, but also, you as the affirmative team have agreed that you have to prove a significant reform through a significant harm and a significant advantage.
Right. Now, going back to our 1AC or our first speech, we talked about how our advantage was that of justice, and we first talked about efficiency. Now, did you contest the issue at hand that 5 9/11 terrorists have yet to be tried within military commissions since 2001?
What was the date for that piece of evidence?
I believe that was I'm not entirely sure, actually.
My entire point was that there's no impact this is not harming American citizens. We're fine with keeping these terrorists away from us so we can feel more safe. There's no tangible harm to American citizens by keeping them in Guantanamo Bay.
Thank you. Now, you also talked about what the actual harms were that we were actually claiming. And you pointed out how a lot of evidence against military commissions actually has to do with human rights issues. Now, in our Fact 2 of our 1AC, would you agree that we read that 24 national security and law experts opposed military commissions because they were not working as intended, and that they should be reformed because they harm national security and the victims, or the families of victims of terrorist attacks?
I don't dispute that evidence. However, just because you read a piece of evidence claiming your contention doesn't mean the debate is resolved. We still have to have a close examination to see if there is actually a significant harm in the status quo, and you have failed to give us any numbers related to that.
Now, going back to your disadvantage, you argued that we are actually undermining national security within our case. And you responded to my point about the Classified Information Procedures Act by talking about how it's up to the discretion of the judge. Would you argue that it's actually harmful for it to be up to the discretion of the judge within federal court?
In certain cases, yes, because the judge does not consider. So if it is truly classified information, sometimes the judge can still be required to provide that information under the Supreme Court case Brady versus Maryland if it's material. And I'm not sure what the legal standard is. In fact, the two law students said that it's a very unclear legal standard.
Right, so within the protecting classified information, so the issue at hand is having the discretion of the judge decide whether or not information should remain classified.
It's not just the discretion of the judge, it's the fact of the unclear legal standard.
Okay.
They were saying that there could still be a possibility
now,
of that.
Did you provide any evidence talking about how military commissions would actually protect classified information better?
So we don't need evidence because of the way military commissions work. There is no requirement of Brady v. Maryland that applies there's no need for exculpatory evidence in military commissions.
Thank you. Now, you talked about international cooperation. Would you agree that Spain only extradited a criminal once he was tried in a federal court?
Well, how could he be tried in the federal court if he wasn't already extradited?
Thank you so much for your time.